Okay, so we're waiting for you all to join, and thank you so much. I see you all coming into this webinar, so welcome. Okay, Dean Robinson, I think we're ready.
Good evening, National Bar members, sponsors, and friends. I am Alfreda Robinson, the President and CEO of the National Bar Association, which is the oldest and largest, predominantly but not exclusively, African American association of lawyers, judges, deans, law professors, and students, and other legal professionals. It is wonderful to have you join us. The National Bar Association has been in existence since 1925 and has continued uninterrupted for 95 years. And we are still growing strong. COVID-19 is an unprecedented worldwide phenomenon that has caused tremendous death, illness, financial, and societal disruption. Our lives, families, and practices have been impacted adversely. So has our association. When we would normally be meeting together, we have been separated because of the pandemic. Just when we really could love to be together and support one another. However, this pandemic gives us an opportunity, a great opportunity to innovate and create new solutions that bring the greatest values to our members and our sponsors. I established the NBA COVID-19 task force to coordinate the NBA's virus-related responses, activities, innovations, member benefits, and messaging, consistent with our bar year theme to keep the NBA moving forward boldly. And we're going to do that during this period as well. One of the committee's undertakings is the development and implementation of a series of outstanding webinars. Those begin this evening with this first one, the subject of which is intellectual property, and features one of our own NBA member and leader, Andrea Evans. The goal is to continue to learn, share, and connect, even during this pandemic. So we begin tonight. But first, let me say this. I invite you to join the National Bar Association, to go on our website, to donate, to send us ideas, and to send us proposals for additional webinars by visiting our website at www.nationalbar.org. Thank you, and let us have a great first webinar.
Thank you so much for the opportunity, and I'm excited to be here, you all. And thank you so much for joining the NBA and the law firm of Andrea Hintz Evans for this opportunity to talk to you all about intellectual property. And I'm going to share my screen with you all and we'll get started. And this presentation is intellectual property protection, patents, trademarks, and copyrights. So let's get started talking about intellectual property, because we all have some intellectual property. And before I dig into patents, trademarks, and copyrights, I want to briefly introduce myself to you all and welcome you again to this presentation. So as Dean Robinson said, my name is Andrea Hintz Evans. I own the law firm of Andrea Hintz Evans, a full service intellectual property law firm. I've had the firm now for 13 years. And in those 13 years, I've represented a range of clients from individuals to Fortune 100 corporations all over the world. And I'm very proud of that because I actually have a very interesting career path. So I'm calling Dean Robinson, the president of the National Bar Association, my dean, because I actually am a graduate of George Washington Law School, and she was my dean at the law school as well as my professor. So thank you again for this opportunity. And then I left GW and worked at the Patent and Trademark Office as both a patent examiner and a trademark examining attorney for 5 years. And I launched the firm basically because one of my mentors pushed and encouraged me to fulfill a need and a void in the community, because so many people, including you all, have some type of intellectual property. And the purpose of this presentation is to ensure that as lawyers, we can counsel our clients effectively and of course refer them to a good intellectual property attorney, but to ensure that you know that this exists. So let's get started. So the first thing is you want to ensure that you know what type of intellectual property someone has. So there are 3 types: patents, trademarks, and copyrights. So simply put, you would patent an invention, and then you would trademark the name of that invention, and you would copyright written works. And so essentially you would patent a television, trademark the name of that television like Sony, and then copyright the scripts of your favorite television show or instructions. So I want to make sure you all have that straight because a lot of people watching will say, oh, I have some type of intellectual property, and you want to be able to distinguish that you patent inventions, trademark brands, and copyright written works. So let's get started talking about patent myths that I know some of you don't have, but it's very common. And a lot of my colleagues will tell me that clients will call and say, oh, I don't need to protect my invention because I mailed myself a copy, or I don't need to, patent in one country. I want to have an international patent. So let's talk about that. So first, mailing yourself a copy of your invention does not protect you. And so I know none of you think that's true, but I'm just making sure, because often people will say, I mailed myself something, I didn't open the envelope, and it's protected. But if that were the case, we wouldn't have patent attorneys in the first place. So I want to make sure you all aren't doing that. Now, the second thing is the patent laws in every country are unique to that specific country. So there is no such thing as an international patent. So I want to make sure you know that there are no worldwide patents. We can file a patent application and apply in every country, and every country has their own laws. So make sure you do that. Now, I'm going to talk about a few things that will help you to understand what can be patented. But when people say, well, what percent of an invention do I need to change to make it patentable? That is a myth. So there's no percent rules. And then last but not least, the patent office is not going to enforce your patent. That's up to you. So we're going to talk about that. So there are actually 3 types of patents. So one is a utility patent, the other is a plant, and the third type is a design patent. So utility patents protect the invention and their features. So let's say, for example, your client comes to you, or you're an inventor watching this, and you say, okay, I invented a chair, and when you push a button, the chair will tell me how much I weigh, for example. So that may have utility, or it does have utility, because the chair is actually functioning a certain way. So that would be a utility application. But then some of you may say, okay, I know a chair exists. I know the chair has 4 legs, but I'm going to have my 4 legs look like smiley faces. And so all you're doing is changing the look or design of that chair. That qualifies for a design patent. So what we have to realize in intellectual property law is, everybody hold up one finger, and that's important because you only have 1 year to file a patent application once you disclose it to the public. And so that's something that I want you all to be aware of, because the clock starts ticking as soon as you make a public disclosure to someone. And so there are 2 types of patent applications. So let's say you're in a position right now where you're ready to pitch at a trade show, or right now during this time, you're going on social media and you want to talk to people about your invention, or you want to have a GoFundMe. As soon as you make that public disclosure, you only have 1 year to file a patent application, or is considered given away to the public. Now there are two types of applications. So one is a provisional patent application. That one holds your date. So basically, if you file today, April 15th of 2020, you have until April 15th of 2021 to file a non-provisional application. And the non-provisional application is the one that we hope will mature into a patent, and that one is actually examined by a patent examiner. So provisionals aren't examined, they're never going to mature into a patent, and you only have that 1 year, remember, to file that non-provisional application, or you lose your rights to filing a patent application. So I want to emphasize that, because often potential clients or inventors will say, I invented this 10 years ago and I'm ready now to move forward to patent this. Well, because you invented it 10 years ago and you've been using it for 10 years, it's not patentable. A question came in and someone said, I want to patent an invention that I saw in Mexico. Well, you didn't invent that invention. So even if someone does not have a patent on an invention, you want to make sure that you understand you can't patent something that already exists. So that's the main thing. The key benefit of filing that actual provisional application is when you're ready to file that non-provisional application, you get the filing date of the provisional application. So you filed that provisional April 15th of 2020. When that time period comes for you to file the non-provisional, even though you file April 15th of 2021, you get the April 15th, 2020 date. And that's going to be critical, because in the patent system, the laws basically say that it is the first to file a patent application. So remember I told you about that myth. So you cannot just add a percent. People want to know, what percent do I need to change my invention to get something patentable? There's no percent rule. These are the rules that we need to understand to get a patent. So the first thing is your invention novel? So that means, is it new? So basically, if your invention exists, whether or not it's patented or not, so you see an ad on Facebook, you take a trip to Hawaii and you see some type of product that you've never seen before, your invention is not novel if it exists already. So that's an easy standard. You don't necessarily need a patent attorney to tell you that. You can look at something and see if it's identical. Now, the next question though is, was it made public? Remember, if it was made public more than 1 year before you file a patent application, it's too late. So if it's already been a year, it's too late to file. Now, is it obvious? So the obvious standard is where you actually would need a qualified patent attorney to help you interpret what we call prior art. So prior art is research. That's the research that was done to help you to see what exists prior to you filing your application. And that's the most important part, if you ask me, of this entire process. And I know that because, having worked as a patent examiner, what we do as patent examiners is examine patents by conducting that research. So you can save a lot of money as an inventor, or you can counsel your clients effectively by saying, look, you need to have research done. So no patent attorney has a crystal ball to be able to tell you if something is patentable. It's always based on research. So the obvious standard works like this. The question is, would it be obvious to one of ordinary skill in the art to take what's out there and combine it to make your invention? Now, what that means in plain English is, if you just change the size of something, or the shape, or the color, those things are obvious. So you come to me and say, I know that the iPhone exists, but I want to make it smaller, or I want to change the color to make it yellow so people can see it at night. Those types of things are obvious changes. So if that's all you're doing with an existing invention, that's not going to be patentable. Now, the last standard is, does it lack utility or usefulness? And that's very straightforward, because all inventions typically have some useful feature, because that's why you invented it in the first place. So before you file an application for inventors, or if you're an attorney and your client comes to you and it sounds great, you know, that they have the next best idea, the most important thing you can do before you file is to obtain a patent search. And so that's where you want to do prior art research. Now I'm going to give you some resources at the end of this presentation where you can go online and start your own research on your own. And that can be very helpful because obviously, again, if you find something that's identical, you stop. If you find something that looks related or close to what you're doing, then you can bring that information in for a consultation to have somebody counsel you on that. But doing those searches actually save you money, right? Because if it's not patentable, you know to invest that money in another idea, because let's face it, you probably have another great idea. But it also helps you to see what competitors are doing. So when we research, we're actually able to see who's already filed patents and who owns patents in that area. And that actually helps you to reach out to them for possibly licensing deals or to see what your competitors are doing. So what I want to do is make sure you have realistic expectations. So the patent process is a very long process. So again, when you file, you can wait almost 2 to 3 years before your patent application is even examined. Now, the patent office does allow you to pay extra fees to have it expedited, but you do have to be patient, you know, because if you don't have the money to pay all those extra fees to expedite your application so that they look at it in 1 year or less, you will be waiting almost 2 to 3 years before they even look at your application. So when you hear people say they're patent pending, that's just what it means. It means that they filed a patent application. Now, the claims are the most important part of this process. And so that's why it's critical to hire a professional patent attorney to be able to help you with your patent. Now, I want to tell you quickly, though, to be a patent attorney, you actually have to have a science or STEM background, science, technology, engineering type of background, have that degree. So my degrees are in mathematics and civil and environmental engineering. And then you have to have a law degree if you want to be a patent lawyer. Now, some of you may be watching and you may say, well, okay, I want to take the requisite classes, because they don't necessarily require that you actually have the degree, but you can have so many hours of science classes to be able to qualify to sit for the patent bar. So you cannot hold yourself out as a patent attorney unless you've passed the patent bar. So I want to make sure you all look into that, and you can find more information about that at uspto.gov, the patent office site. Now, the claims are part of a patent application, and that's what people basically, that's what the patent office examines, and that's what people infringe. So when you hear someone say, such and such has infringed on my patent, it's not all the write-up and the background that's in the patent application, it's the claims. So when I worked at the patent office, there was always this saying that I want to share with you all, that the claim is the name of the game. So that is the most important part. So you want to make sure your claims are written in a way that they're not so broad that they cover everything, because then you'll spend a lot of money trying to really claim the real invention, but you don't want them to be so narrow that they're easily infringed by someone. So once you file, and this is either with the provisional application or a non-provisional patent application, you're patent pending. So when someone says they're patent pending, that's just what it means. They filed their patent application and it's pending. But remember, you cannot enforce a patent application until you get a patent, right? Because there's no guarantee that you're actually going to get a patent. So just because you file a patent application, that does not mean that you actually can start suing and enforcing a patent application. So just make sure you're clear on that. Now, during that time, some things that you can help your clients do, or some things that you can do if you're an inventor watching, are consider manufacturing or developing prototypes, because you don't actually have to have a prototype to file a patent application. So that's something that is very important that a lot of people don't often understand. As long as you can describe your invention in a way that someone can make or use it, you can file a patent application. Now, another thing to consider is, remember, we are talking about filing US patent applications, right? But you may say, I know that I'm going to make this invention in China, or I know that I want to sell this in India. And the patents that are filed only cover you in the US. So you have that 1 year to file in those foreign countries. So at that time, that's when you can start considering filing in those countries if you didn't file when you originally filed the application. And again, when you file, you have to be patient because it can take, 1 to 2 years, but it's more like 2 to 3 before the patent office looks at your application. And just because it takes that long, it doesn't mean it's a problem. It's just that we live in a country, thankfully, that there's innovation and creativity and people are taking advantage of the patent system. Now, once you file, your application is still not public, but 18 months after you file, it does become public. So once you get a patent, you can stop infringers. And the beauty of intellectual property is that whatever you can do with real property, you can do with intellectual property. So you can license it, you can assign it, you can sell it, you can will it. And I love that because it's something that can live on forever. This is when we talk about a legacy, especially during this time, people look at their life and the legacy that they're leaving behind. Your intellectual property is part of that. So you can actually patent something, get a patent on an invention, and license it so you don't have to make it, and then maybe get $1 every time they sell or make your product. So that's definitely something to consider. Now, the system used to be the first to invent. So it used to be that whoever invented something first would have priority, but now it is the first to file. So you definitely want to encourage your clients, and if you're an inventor, you definitely don't want to wait, because once you file a patent application, you get a filing date, and when the government does that research to see any prior art that exists prior to you filing, they're looking to beat that date. So if someone filed or if someone posted a video prior to you filing that application, that's prior art. So you definitely want to encourage your clients, and if you're an inventor watching, you definitely want to file right away. So we're going to move on to trademarks. And trademarks are just as important as patents, but it's very interesting because you don't have to be a genius to know that you need to patent your invention. And why I say that is because if you've been watching TV, you've always seen that commercial. Have you invented something? Time to get a patent. But you never hear people talk about trademarks. And they're very important, just as important as a patent. So remember, patents protect inventions. So now we're going to move on to trademarks, and trademarks protect the names of those inventions. And what's required to be a trademark is it has to be a source identifier. And so what I mean by that is my firm is Evans IP Law. So let's say you love the name Evans IP Law and you call and say, I want to trademark Evans IP Law. Well, you can't just protect your favorite word. It has to actually be for a product or a service that you either are providing or you intend to provide. And that should make sense because you just can't own rights in one word. You have to identify what it's for. So that's why as consumers, we go to the store and we may see a company, Evans IP Law, the law firm, but we may go to the store and see Evans IP Law for cookies because we're going to coexist, because you wouldn't expect to see a law firm selling cookies and a cookie company providing legal services. So let's talk about trademarks. So trademarks, we're all experts already in trademark law. And I say that because we are all shopping, whether you're shopping online now or using services like Instacart, you're an expert, believe it or not, because you're a consumer. But I want to make sure you're clear on some myths that people aren't always clear about. So often people don't recognize that you can actually trademark a scent. You can trademark a sound and even a color. So let's say, for instance, the NBC sound. Doom, doom, doom. So that is trademarked. The red bottom shoes. Or how about if I hold up a blue box, the Tiffany blue color box and a black box, and say, hey, which one do you want? You're probably going to say the blue Tiffany box, because they have trademarked that color, and that color is symbolic with their brand. So that's the way you want to start thinking. And you actually can trademark 3D shapes. So the most famous 3D shape is the Coca-Cola bottle. So that glass Coca-Cola bottle is actually trademarked. So they've proved that when people see that shape of that bottle, they identify that with Coca-Cola. Now, this is often a big question that comes up often. When can I use TM and when can I use the R symbol with that circle? Well, those two things are not synonymous. So right now, if you're starting a business and you have not filed a trademark application and you don't have it registered, you can put the TM symbol just to put others on notice that, hey, I'm using this as a source identifier. So ABC with the TM next to it. But once you get the actual federal trademark from the USPTO, you put that R symbol with the circle, and that puts others on notice that you actually protected this federally with the United States Patent and Trademark Office. Now, another thing I want to talk about is domain names, because people will say, I have the domain name abc.com, so I own the rights in ABC, but not necessarily. And it should make sense to you all, because if I tell you the name of my brand is ABC, you know that as a trademark, you know, because you see that on the sign of the store, you see that on the price tag of the shirt. But if I say, come to 12345 Main Street, that's just the address. But when you get there, you see ABC on the wall of the store. So the brand is actually ABC. Same thing with the domain name. You see that as abc.com, but when you get to the site, it may say, welcome to, you know, the law firm of ABC. So the brand may actually be the law firm of ABC. The domain name may not function as a trademark. But I do want to tell you that domain names can be trademarked if they function as a source. A good example of that is Match.com. So these are some issues that you want to definitely consider as you're counseling others. And for entrepreneurs, you definitely want to think about all these types of issues that can arise that aren't so straightforward. Now, also, just because you own the rights of a name or a brand in a state does not mean you own federal rights. And so you want to make sure that just because you form an LLC, for example, does not mean that you own the trademark. And just because you own the trademark does not mean that you formed a business. So you definitely want to understand those myths. And I'm sure you all definitely, maybe you didn't know those, but I'm glad to tell you about those. So trademarks, before you file, you want to identify how strong or weak your trademark is. And so what I mean by that is there's a spectrum of trademarks from generic to weak, you know, to strong. Now, the stronger trademarks are words you make up. So Google, for example, doesn't mean anything in the dictionary. You made that word up. That's going to be the strongest trademark, and that makes sense. It should be, because you made that word up. Now we move down the spectrum to words that we call arbitrary trademarks. Now that's a word that may have a dictionary meaning, but it doesn't mean anything related to the product or services. So Apple for computers. We know Apple is a fruit, but it's very strong for computers because it doesn't mean anything related to computers. Now you actually can trademark a descriptive term. So you actually can trademark lavender lotion because it's describing that your lotion is lavender, but it's going to be a weaker trademark because it's descriptive. And so if you file a trademark that's descriptive, you have to be prepared for others to be able to use those words in a descriptive way. So I can trademark something that's descriptive and use it as my brand, but don't be surprised if someone is using that expression to describe goods or services, you know, which you may or may not want. And then you definitely cannot trademark generic words. Shoes for shoes, lotion for lotion. And that should make sense because owning a trademark provides you with these rights to be able to stop others from using similar marks that may cause confusion. So I want to point out, like I said earlier, that once you create that name and you have this strong name, you have to identify all the goods and services that you're using it on or intending to use it on. So that's right, you can actually counsel clients as soon as they create a name and they intend to use it, you can file a trademark application. So you don't actually have to be using the trademark, meaning making money in and out of state, you just have to be intending to. So I intend to use ABC for a law firm. I haven't started the law firm yet, but I intend to. I can file a trademark application, or I may actually be using it already. So some of you may be watching and you may say, look, I've been in business 10 years and never got a trademark. So you're actually using it. So it's one or the other. You're either using it when you file or intending to use it. And using it means using that trademark for those goods and services in what we call interstate commerce, so outside of the state. So that is a requirement for trademarks. You do have to either be using it or intending to use it outside of the state. So at least what you need to get a filing date for your trademark application is at least you have to have the name of the owner and their mailing address, and the USPTO is now requiring an email address to be published on their applications. You have to identify those goods and services that we talked about. And again, that makes sense because if somebody else files ABC for cookies, then they're not going to be blocked by ABC for legal services. So you do have to identify that, and you have to identify what the trademark is. So the trademark could either be the words ABC, or maybe I have a fancy logo where all the letters are made out of smiley faces and I'm going to upload that. So I either have a word that I type in, or I may have a design that I upload. And of course, the patent office is like the post office. They require their money. So you always have to pay your filing fees and have the name of the applicant, the drawing, and identify those goods and services. So once the application is filed, so the beauty of this is there's a theme to me regarding intellectual property, and that's that searching and researching is critical. So again, you're going to research before you file a patent application to determine if something is patentable. And if you've done what we call your due diligence to ensure that no one has a name that's similar, you should be okay, you know, with this process. So before you file, I definitely want to emphasize that you get a professional trademark search done to ensure that no one has that name. Now, I'll tell you what though, if you are going to Google and you Google ABC for a law firm and you notice that someone else has it, a lot of people call my firm and they say, oh yeah, that person has it, but they didn't file a trademark. Well, remember, again, for trademarks, it's the first to use. So even if you get a trademark register, if someone can prove that they used it first, they can challenge your trademark and take it from you. So you want to make sure that you've done your research and you can ensure that you used it first. Now, once you file, the government's going to be looking at what we call a likelihood of confusion. So does it sound the same? Does it look the same? Is it on identical goods and services? So that's what they're going to be looking at first. So if I'm ABC, the letter C for a law firm, and you come behind me and you want to be ABSEA, which is pronounced C, then we're going to have some problems, because obviously when someone calls the ABC firm, they don't say, is this the ABC, the letter C, or is this the ABC SEA firm? So, and I want to emphasize that because people will say, well, they have my ABC, or I'm going to be the ABC. But again, that's confusion. So step back, because we're experts as consumers, and ask yourself, would someone be confused by that? And if they are, then you want to change the name. Now, they also look to see if something is misdescriptive or if it's descriptive. You can get a refusal on that. Or how about if it's geographically descriptive, Texas barbecue ribs, and you're selling ribs from Texas. Or you actually can trademark your surname, like a last name like Evans can be trademarked. It's just a weaker trademark, but these are things to consider before you file and things that you want to pay attention to. Now, there are several benefits of trademark registration, because people form companies, and many of you help to form corporations, and you should be encouraging your clients to protect their federal trademark as well, because doing that puts others on notice. So there's a constructive notice that you own it. And so you have that R symbol there, you've registered, it's a presumption that you of ownership, which is fabulous. Now, the other thing is that this is a federal issue, so you can actually have jurisdiction in a federal court. And also, you can claim registration benefits in other countries, sometimes as priority, to say, okay, I filed in the US, I've used it here, and that depends obviously on the country. But also, you can actually register your trademark with customs to help prevent infringing products. So when you see those busts in New York and things like that, that's because people have actually taken the time to register their trademarks to prevent those types of products coming in. So I want to give you all some social media tips here. If you're counseling clients on trademarks, and if you have registered a trademark, you definitely want to reserve your username on social media. And so I'm saying that because so many people now are taking advantage of social media during this time. We're being innovative and creative ways to reach you all. And even if you don't plan today to ever post a video or to ever post on Twitter, you want to reserve that name that you plan to use as your brand on social media so that you have control over it. And so by the time you trademark ABC and say, okay, fine, I'm going to hire someone to do all my social media, you want to have the @ABC as your handle so you can have control over it, because that's the way consumers are trained anyway. And that should make sense, right? Because when I'm looking for ABC, I don't want to go to my ABC or the ABC. So if possible, before you launch a business or have a product with a brand that you plan to trademark, get the .coms as well as reserve the social media handle. Now, you definitely want to police your trademark. So often people assume that because you've registered at the USPTO that it's up to them to stop others from using it, but it is up to you. And so you want to make sure also that as you are monitoring your trademarks, because that's your responsibility to do, that when you see others using your trademarks, you just don't sit back and watch it happen, because there can be case law to support that if you know someone is infringing and using it and you sit back, that you've given them permission to do that. So just be very careful with that. The beauty of this, though, is if you have a trademark and someone is infringing and they're using your trademark on social media, right now, all of the social media have trademark policies and trademark attorneys that we talk to be able to say, hey, I have that trademark. So that's the benefit. Remember, the presumption of ownership. So they respect intellectual property rights, and that is definitely one of the benefits of having that trademark. So you want to be able to shut down others from using your brand so you have control over it. Now, there are 3 types of intellectual property, so I definitely want to talk about copyright. So again, we patent inventions, trademark the names of those inventions, and copyright written instructions. So the USPTO, United States Patent and Trademark Office, is the agency that is in charge of patents and trademarks. So when you file a patent application, remember, it's examined by a patent examiner. When you file a trademark application, it's examined by a trademark attorney. Now, the Library of Congress is the government agency that handles copyrights. But unlike patents and trademarks, they aren't looking to see if someone has filed something similar. So you write a story, they're not going to read that story and compare it to John Doe's story. They're going to review that application to ensure that it meets the legal requirements, but they aren't going to examine it in the same way as a patent and trademark. So you cannot copyright a name, right? And that should make sense because we just talked about trademarks. You can trademark a name, but remember, it has to be for a product or a service that you intend to use or that you're actually using. So that favorite word that you have in your mind that you want to protect has to be used on something or intended to be used, and that's protected with a trademark. Now, everybody's using Google these days, and they're copying and pasting. And they say, okay, I'm going to copy this presentation and put it on my site. Well, even though you aren't charging people to watch the presentation, that's copyright infringement. So these slides are protected by a copyright. So that's a good example, because people say, well, I didn't make any money off of posting your picture on my blog, or, I even quoted you. That should be enough, but that is still copyright infringement. So be careful with that. However, a parody is considered fair use. So you make fun of someone, in a funny way, or you show the video and you criticize that person or what's happening in the video. That is fair use, so that is okay. Now, people assume that posting on the internet means that it's free. But just because it's posted on the internet, it does not mean that it's fair game for you to use that and take it off the internet and claim it as your own. So here's a list of things that can be protected with the copyright. So literary works, musical works, dramatic works, pantomimes, sculptures, motion pictures, sound recordings, and architectural works. So those are things that can be protected with the copyright. But the beauty of copyright law is as soon as you put the pen to paper, so if you're taking notes right now, you actually own the copyright right now without registering it. However, the benefit of registering it is if you register your copyright before it's made public or before it's published, you get more damages than you would have had you waited to copyright it after someone copies it from you. So definitely encourage others to protect their copyrights before they make the written work public. Now, we talked about the R symbol with the circle around it to show that your trademark is registered. You've seen this C symbol with the circle, and this basically informs the public that the work is protected with the copyright. So you'll see the copyright symbol with the C, the owner, and then usually the year of the first publication of that copyrighted material. So that's what that means. Now, the benefit of registering your copyright is that it establishes a public record of the claim. And so that's important because you want to basically establish ownership. Now, here's the deal with copyrights though. So remember, I told you that as soon as you put the pen to paper, you own that copyright. But if someone copies it and you don't have it registered with the copyright, you are required to register that copyright with the Library of Congress before you can sue someone for copyright infringement. Now, it's going to cost more because all of this stuff that I'm talking about takes time. So remember, we said patents can take 2 to 3 years before it's examined. Trademarks can take 3 to 4 months, but the entire process can take 12 to 18 months, maybe longer if it's challenged or longer for extensions of time. Copyrights can take almost a year before the application is examined as well. So before you can actually file a lawsuit for copyright infringement, you are going to be required to have that copyright registered. And again, similar to trademarks, registering that copyright allows you to record that registration with customs as well. So I wanted to share these resources with you all. The most important to me regarding patents and trademarks is uspto.gov. So that is the United States Patent and Trademark Office site. Everything is electronic now. So electronic filings are actually now required for trademarks. And you still, now there's, because of the COVID pandemic, I'm not sure what they're doing with you being able to drop off files at the Patent and Trademark Office for your patents, but you can have paper filings, but they have a very robust and innovative filing system. So they require that you file online for trademarks. And you want to make sure that if you're counseling clients, that you encourage them to hire a professional and you understand trademark law, because often they assume because the document seems so simple, like I know that I'm answering questions, but it is a legal document. So I want to caution you all, because I also do intellectual property litigation. And if we can find some holes in your application, you can't say, well, I didn't know, or, I assume this is what this meant. It is a legal document. Now, I encourage you all to do some research. And so the best and free tool for research is google.com/patents. And you can go in and key in some keywords about your invention. And if you find it, we know that you stop and move on to something else, or bring those references to a qualified patent attorney. Now, I definitely don't recommend to use this as a substitute to hiring legal counsel, because your search may not be as thorough as a professional, but it is a good start. Now, I've actually authored 2 books all about trademarks and all about inventing. And those are sold on my site as well as Amazon. I'm very proud of them because they're the first books written from the perspective of a former patent examiner. We're all about inventing, walks you through the process of going from an idea to an invention. It tells you what to expect once you file a patent application. And I think this is critical that we all understand the process because you know what to expect. And then all about trademarks walks you through the process of creating a brand, ensuring that it's strong, and understanding what to expect there. And then last but not least, copyright.gov is definitely where you're going to go to find out more information about copyrights. So my trademark is invest in your idea, and I want to definitely encourage you all to invest in your ideas. And I want to encourage you all to definitely support the National Bar Association for things like this. And the first thing I want to tell you about is that the National Bar Association Intellectual Property Law section is actually taking nominations as we speak through April 30th of this year for the 2020 Diversity in Tech and IP Awards. So you all can visit www.diversityintechlaw.com and feel free to nominate your favorite intellectual property superstar or nominate yourself for that. So I definitely want to encourage you all to do that. And last but not least, I definitely want to encourage you all to join the National Bar Association. Some of the benefits are discount programs, advocacy, having this national network, professional resources, and so much more. The friendships are endless and the relationships are priceless. So thank you all so much. I'm going to stop sharing my screen and I'm going to answer any questions that you all have. So I saw some questions coming in here and you all sent me some questions. So I'm going to start answering questions. So post your question in the Q&A box and we'll take it from there in these last few minutes. So the first question that came in was, what recommendations would I make to an innovative technology firm in looking forward to developing technology and planning ahead for intellectual property? So that is a good question. So once you have made a decision that you want to focus on intellectual property, or really any type of law, to be honest, I would say, especially during a time like this, technology is critical. So you want to make sure that you have your systems in place. And this comes from the engineer in me. Everything needs to be spelled out in a way that if you hire someone, that person knows from A to Z what they're supposed to be doing. So regardless of if you're a family lawyer or intellectual property lawyer, to plan ahead, you need to have your systems in place. So do you have forms where you have the questions that you need to ask during a consultation? What information do you need? And because the process is so long, you definitely want to ensure that you have a docketing system in place as well. So the next question is, how does a young attorney interested in IP law become more involved and knowledgeable about this area of law? So the IP section of the National Bar is definitely a valuable resource. I highly recommend you all consider joining this section. AIPLA, the American Intellectual Property Lawyers Association, is another valuable resource that I recommend. And I also recommend that you find a mentor in this particular area, someone that can help you so that you're not reinventing the wheel. The next question is, someone had a specific question about grief cards in stores. So now that you all are experts on intellectual property, we can answer this question together, because if you want to put cards in a store, do you need a patent, trademark, or copyright? So the beauty of intellectual property is sometimes you may have all three, sometimes you may have one, but again, everybody has some type of intellectual property. So the names of the brand of that grief card, the ABC grief card brand, is going to be protected with a trademark. And then the content on the card will be protected with the copyright. The illustrations will be a copyright. So that's something to consider. And then let's say you have some innovative technology that actually allows you to print cards in 1 second or less, that may be patented. So that's something to consider. So someone said, how long can you use TM before filing? You can actually use TM without filing an application. So that's a good question. But in terms of enforcing your trademark, we have what's called common law rights. And so what I've been talking about are federal trademark rights, which cover you in all 50 states. If you have a trademark and you put TM, that means that you didn't file, but you're using it in common law. So I hope that answers your question. And the next question is, how can I protect my patent when I present my ideas to a lawyer? So when you are working with a law firm or a lawyer, that establishes an attorney-client relationship. And attorney-client relationship allows that information to be confidential. So that's a good question, because often if someone calls and says, I need my attorney before I can talk to you to sign a non-disclosure agreement, that's kind of a red flag that you're not familiar with the process. And so you want to make sure that it's to understand that it is not necessary. But that's a great question, because an attorney-client relationship keeps this conversation confidential, and it doesn't start that clock that we talked about. Remember, you have that 1 year, but then when you go present your idea to Bob the Builder, that does start the clock. And so that's a great question, and that relationship is not necessarily confidential. So thank you for that question. Now let's see. The next question is, if a firm knows that it will be doing business globally, should the company file a patent, trademark, and copyright concurrent to filing in the US? So that is a good question. So the short answer is it depends. And I say that because remember, in the patent world, you only have 1 year. And I'm emphasizing that because what's interesting about the US patent system is you can file an application and you don't even know if your application will be granted in 1 year. And so it's very interesting. So you want to make sure you're working with an attorney that's going to keep up with that 1 year time period to remind you that, hey, the time is coming for you to be able to file in these other countries. Because if you don't file in those other countries within that year, you lose the right to file. And so there's no rule that it should be filed at the same time, but the laws do afford you, and we didn't talk about this, but there is something called the PCT application, Patent Cooperation Treaty. And several countries are part of this one treaty, and that allows us as US attorneys to file an application and designate when we file which countries we're interested in filing those patent applications in. Now, from a cost perspective, what you have to understand is every country will have their own attorney, and all those applications will have their own fees. So you definitely want to be prepared and budget for that. But I have a lot of experience filing those applications, and I'm proud that my clients have multiple patents in other countries. And mostly what will happen is the firm has relationships with other firms in other countries. So thank you for that question. And someone is asking a question that they found a product with a similar use. Okay, so that is a great question, because often what happens is, let's say I patent a pot and you push a button and the pot allows you to cook food in 2 seconds or less. And then we have a hurricane and you put that pot on your head and say, Attorney Evans, I need to patent this pot. Now, when it's time for us to patent that invention, remember, it's the same pot. So for the patent system, we don't necessarily care what the invention is used for, because when we describe that pot as having a handle and having an opening and having a button on it, it's going to be the same pot. And that should make sense, because if I patent that pot and then you go and start packaging it up and saying, okay, now this pot is a helmet, it's still my pot. So if something already exists and it's used for a different purpose and it is the same invention, although it's used for a different purpose, that is not going to be patentable. So you all have a lot of good questions. One of the most important questions is, can you see this presentation again? So thank you. That means you loved it, and I appreciate that. And yes, you can. We will be emailing out a link for you to see this again, and I appreciate you asking that question. The other question that you have is, how do you find a manufacturer or someone to develop it? So remember, when you have an invention and you are in a position where you can actually describe it in a way that someone can make or use it, to file a patent application is not required that you have a prototype. Although some people do basically, they want to be able to say that I know that this is how it works, and they feel very confident about that. So how do you find a manufacturer or someone? You're going to have to do some research in that area and ensure that it's someone that you can trust and you have a relationship with. And so I don't have a direct answer of who that person would be, but you want to make sure it's someone that works in that particular area. So you don't want to go and hire someone that manufactures toys to manufacture your kitchen tool. Okay, so I answered the question about seeing this again. And next question is, if you hire an attorney that you don't feel confident in working with because they aren't well versed in IP law, you missed the deadlines, they're both dead. Oh, sorry to hear that. Now, to answer that question, just like any other area of law, if you don't feel confident with that attorney, you can actually fire the attorney. And so lawyers can fire clients, and clients can fire attorneys. And it's not personal, it's business, and it does happen. Unfortunately, if you miss the deadline for a trademark, for example, if the trademark is abandoned, then you have 2 months from that abandonment date to pay a fee to revive that application. Or unfortunately, you do have to start the process again. And so if that has happened, you are going to have to refile that application. Now, here's the deal with that. Let's say you refile the application, and during that time, John Doe beat you to the filing. So now John Doe is in front of you at the trademark office. What happens then is that John Doe's application will be cited against you. So unfortunately, even though you originally had it filed and you beat Jane Doe, you start over with a new date. But remember, for trademarks, it's the first to use. So if John Doe filed it before you, but you can prove you used it first, you can challenge John Doe, but the challenge is litigation. So it can get to be costly, but that's why time is of the essence when you think of intellectual property. So that's definitely something to consider, as you, and hopefully this inspires you all to start taking action, which I appreciate it. You all have a lot of questions here. So the next question says, what's the best resource to use to conduct a global search as to whether prior trademarks exist? So that is a good question. Now, every country has their own rules for trademarks. And I say that because often, let's say you file ABC in America, if someone is exclusively using ABC in Italy, you aren't going to have any problems because they are in another country. Now, in order to conduct a global search, there are third-party vendors that you can hire to look up or attorneys in those countries that can do those searches, or we have software that also allows us to do that search. But I wanted to say that because I want to emphasize that if you find someone using your name in the US, then that will be a problem because they're using it before you, even if you beat them to filing a trademark. So people say, oh, this is a little boy selling ice cream on the corner and he doesn't have a trademark, so I'm going to take that name and file it for an ice cream store. He can challenge you because he used that name before you, whether or not he's big or small. So I answered the question about filing an application for a new use for a product, even if it's in a different industry. If that product is the same, it's not going to be patented. And let's see. Next question. Oh, so free resources for the patent bar. I'm not sure about free resources because it's changed since I've taken it. But you may want to contact the United States Patent and Trademark Office and see if they recommend a resource to take it. Now, the patent bar is now online, and so I'm not aware of any course materials that are free, but there are some that will allow you to take the class online. And I believe their practice tests online, but that's been so long that I'm sorry, I don't have an answer for that question. And let's see, slogans. So that's a good question. So again, if you are using your slogan as a source identifier, like we talked about, where that slogan allows people to perceive it as a brand. When I say just do it, my trademark is invest in your idea. So as long as you're able to identify goods and services that you're using or intending to use that slogan on, it can be trademarked. So slogans can be trademarked. So let's see. It is important to ensure that you are maintaining your patents and trademarks. So copyrights last for your life plus, I believe, 70 years after you pass. So, you know, that you don't have to actually maintain in the sense that you're paying fees along the way. Trademarks, though, once you get a trademark, every 5 years after you get that federal trademark, you do have to remember to maintain it by filing a fee with the United States Patent and Trademark Office and signing a legal document to let them know that you are still using it and showing them that you're still using it. And that makes sense, and that's a great question. When I think of Coca-Cola, Coca-Cola has the oldest trademark, so they've owned that brand since the 1800s. So we know how important trademarks are, because you pay a few $1,000s to get a trademark, but the trademark is worth so much more because it's worth, you know, so many years. You've used it for so many years that it has this incredible value. But yes, every 5 years, you show that you're still using it. As long as you're using it, you get to keep it. And if you stop using it, then it is fair game for someone else to come behind you and file that application. And so, yes, once an application is filed, you can actually delete trademark goods and services. So let's say you file and you think that you're going to use it on soaps and hats and shirts. You can delete goods and services after you file, but you cannot add them after you file. So that is a good question, and it comes up often. It's not the end of the world, but you do have to file another application. So, boy, I'm going to have to talk to the National Bar to come back to answer all these questions. We have so many questions here, and they're great questions. Let me see. Someone said, okay, so let's say you do have to put an address on a trademark application. That address does become public. The USPTO just changed the rules. You cannot file an application with the PO box anymore. They do require a physical address. Now, the worst thing that happens with posting that physical address is spam mail. You get a lot of solicitations and things in the mail. But if you move, it is your duty to keep the office aware of your current address in case someone needs to reach you to file a cease and desist letter or for renewals. But again, that's your responsibility to keep up with those dates. And so you do, when you're considering allowing or having this IP as part of your law firm, you want to make sure you have the right systems in place to keep up with all these very important dates and critical dates. So another question that someone asked that I thought was good is that how does a new attorney build a law firm that specifically focuses on intellectual property law? So that's what I did. So I can tell you what I did. So I started my firm 13 years ago. And what's unique is that I worked at the Patent and Trademark Office as a patent examiner for 3 years and a trademark examining attorney for 2 years. But what has always been a gift for me is having a network and understanding the importance of a community. And so I would often get calls from my colleagues saying, did I have a referral for a patent lawyer? And I would often, as a patent and trademark examining attorney, hear heart-wrenching stories from people who were trying to file on their own, because let's face it, most people don't want to hire an attorney, and the number one reason is because of money. But that is why my trademark is invest in your idea, because it is an investment. And if you file these applications incorrectly, you can jeopardize your rights, and some things cannot be fixed, you know, and will ultimately cost you more money. So I'd rather have be a resource where we can counsel you and at least tell you what you need, so that you know what to expect versus trying to fix your mistakes, because it can cost more to have an attorney fix your mistakes. And so after getting a call from one of my mentors who said I was feeling comfortable at the Patent and Trademark Office, he said, you're going to be working from home. And I loved it there. I loved the lifestyle of knowing what a production system was and just basically knowing what was expected. If I wanted to get a bonus, I knew how many extra cases I needed to examine. But he said, hey, you're getting all these calls from people in your community, and that's a sign that maybe you need to be doing something else. And really, that's all it took. I never really planned to start a law firm, but I stepped out on faith. I put in my 2 weeks notice, and I did not have any clients because I was working for the government. So often if you're at a firm, you can take your book of business with you, but I did not have that. So I bought a computer, I had a contract, and I was ready to go. And luckily, I talk about the importance of community because I sent a blast email message out to everyone I know, everyone I knew at the time on my email list to say, hey, I'm starting a firm. And sure enough, people started calling. People needed my services. And 3 months after I formed my firm, I was very fortunate to obtain a Fortune 100 client because of my reputation and because I had that skill set of working at the Patent and Trademark Office. And my firm outperformed all the firms that were on this specific project. And it just gave me so much more confidence, because if you are starting a firm, we're all intelligent and qualified to be able to do this work, but you have to have a level of confidence because it's very challenging. And it feels good to know that someone will invest in your firm to be able to do it. And long story short, I did not have a huge marketing budget, but I took total and full advantage of social media. So I started with Twitter, posting things, and then I had Shark Tank retweet me. And then because I was available and posting information about intellectual property, I had national publications contact me to be quoted in magazines, and the rest is history. So I want to thank many of you who are already part of my community for participating in this event tonight. And if you're not on my firm's newsletter, please subscribe. You can go to evansiplaw.com and you can text Evans IP Law to 33777 if you want to join the firm's newsletter. But to answer that question, how does a young attorney build a firm with this practice? And if you're a young attorney watching, how you do it is you start by having that confidence and you take action. So many people have ideas, and this applies to inventors, this applies to attorneys who are kind of on the fence about what to do. And the difference between $1 million inventor and $1 million person running a law firm is that they took action. So the key is to start, and there are no real rules of how this is done, but you start, and you have to let people know that you're out there. So with any product that you have, any business that you have, you can post a website, but no one will come to that website unless you are taking action to let them know that you exist. And then once you do a good job, which you're going to do because you're passionate about what you do, your clients will tell other people, and then their community becomes part of your community. So I've built my entire firm for 13 years around having a community. So that is extremely important. So definitely, if you don't have a budget and you're a young lawyer watching, take advantage of social media. And the way you do that is by providing information about yourself, but balancing that with information that your community can use. So that is what I'm going to leave you all with. And I want to thank you all for definitely watching this presentation today. Thank you so much to the National Bar Association for this, and make sure that you all follow the National Bar Association because they have other amazing lawyers who will be presenting on their area of expertise. And this was amazing. And I know you all have many more questions, so feel free to reach out to my firm if I can help you with your specific issue. And let me just skim this long list of questions again to see if I can answer some quick questions, and then I'm going to let you all go. And this presentation was recorded, and we will share this for those of you that want to see it again. And let's see. So once a trademark application is dead, is it possible to have it revived? No, I answered that question. You would have to start that again. But if a trademark is dead, it may be possible for someone else to file. The next question, let's see, from lawyers, I want to answer. Oh, thank you so much. I appreciate your feedback. Someone wrote this was great. Thank you. Thank you so much. I'm glad you all enjoyed this presentation, and I'm glad that you all are supporting my firm, the law firm of Andrea Hens Evans, as well as the NBA. So ladies and gentlemen, thank you so much for joining us tonight. And I'm so excited that you all are excited about intellectual property law. So I want to leave you all with understanding and knowing that patents protect inventions, trademarks protect the names of those inventions, and copyrights protect written works. If you are a lawyer and you're interested in finding out more about structuring your law firm so that you can focus on intellectual property law, please reach out to my firm. I'm happy to help you there. And you can also reach out to me at boss-squire.com for all lawyers. And thank you all again so much. Follow Evans IP Law and follow the National Bar Association for more valuable content like this. Have a good night, and thank you so much.